Now, first thing first, this legal Q&A is to educate and to provide general information. And before you rely on the information that presented here, you should consult with the attorney. Let me tell you why. Information will create awareness for you, okay? Where the information become the solution for your situation is you take your facts and the information that we presented here or in the future Q&A and merge them together and do an analysis. And that's where you will come up with a solution. And generally, you need to talk to an attorney when you do this particular analysis with facts and it all. So that's why I always recommend before you take any action, always consult with the attorney. If you are interested in establish attorney-client relationship with our firm, please give us a call after Q&A. We love to talk to you about the possibility of being hired as your company's general counsel. This kind of related to the first one, and I've been asked a lot, is customer list considered as a trade secret? You know, as a business owner, I understand client list, customer list is the most important asset for me and for a lot of business owners, okay? But whether or not they are trade secret that is protected by law, I don't know. I would say most of the customer lists are not, okay? See, the court is really reluctant to recognize the customer list as a trade secret for a number of things, right? Because of this strong public policy that employees or anyone has a right to make a living. And if this person is the employee, you know, he or she can use the general knowledge, skill, or experience that he acquired to make a living. They have that right. Even if the skills, the knowledge and experience was gained or acquired from previous employment. And even though they use the same set of skills, knowledge, and experience to set up a competing business, right? They have a right to make a living. Now, that doesn't mean that they can do whatever they want, but that's just a public policy the court has. They, when they evaluate this kind of situation, they have that in mind, whether or not I'm gonna take the opportunity of make a living from this person. So they have to do a balance. Now, the customer list can be protected as a trade secret if you do two things, okay? Number one, if you expend time and effort identifying the customers with particular needs, okay, or characteristics whose identity were not readily ascertainable or is not available in public. Number two, you got to take reasonable steps to maintain the secrecy. Two things the court will look at, okay? Now, what do you mean by, spend some time and effort, identify the customer with particular needs? Okay, let me give you an example. If you just got a list of customer, let's say from Info USA, it's not confidential information. It's not trade secret, unfortunately. Even if you compile information from internet, which is so rarely available these days, they're not a trade secret. However, if you develop that list, if you spend like 3-4 years to develop the list, and every time you talk to a customer, you jot down the information or take notes, in 4 or 5 years, you have this accumulation of the notes for these customers, that is the first step to turn this list into a trade secret, okay? The list itself is not a secret, but the information attached to that list the information attached to that particular customer. That's what makes the list a trade secret. Okay, so let's look at an example. In previous cases, you know, the company can isolate the customers who is going to buy what product, and who are the top, in this case, top 6.5% of the customer is predisposed to buy company's product or certain product. Okay, we know there are a general list of customer to a short list of those who will actually buy what product at what time, at what season. Okay, or the list has the sophisticated information attached to it, like building rate, the key contract that they signed before, special requirements that they need before they will order the goods, and the markup rates, things like that. So list itself is not trade secret. If you have information that you spend time and money on to accumulate and it's not available in public, that's what makes it list potentially trade secret. And the reason I say potential trade secret is you also need to take steps to make sure to treat this as a secret, right? If you don't treat your customer list as a secret, guess what? The court will not do it as well. If you don't think it's a secret, then what should court do? Consider the list as a secret. It's pretty logical. So what you need to do is you need to advise the employees that certain information is a trade secret, okay? And you need to have limited to access. Put the information in the vault or in locked drawer, things like that. Sign a confidentiality agreement, and have this policy in the employee handbook. What are the trade secret of the company? What are the confidential information of the company? The exact steps that they need to take to preserve that secrecy, and also that just provide, if you have a trade secret, then you provide this employee on a need-to-know basis. Now, the classic example that I always give to my client when they come to my office and explain to them is, the formula for Coca-Cola. It reportedly say only 2 people knows the formula, the original formula for Coca-Cola. I don't know how true is that, whether or not it's more than 2 or just 2, or even it's relevant now, because there are so many kinds that the energy drink seems to be a big surge for recent years. Take a lot of market space, market share for the soft drink market. Now, that's type of the treatment that you need to treat your confidential information, is to protect it, treat it as a secret. Let employee know as on a need basis. Okay, if you do that, then court will realize, hey, if you do that, then the court will treat it as a confidential information as well. Now, generally speaking, is that the more difficult the customer information is to obtain, the more time that you spend on it to develop the additional information that is not known in public, the more resources that you spend on the list to compile this information, the more likely that the court will find the information constitute a trade secret. And just on the opposite side, if you just buy a list from Info USA, for example, or you compile from internet or doing the Google search, unfortunately, those lists are not trade secret. If you 4 or 5 years down the road, you compile a lot of information that is not known in public through the personal contact, for example, through some relationship developing. You learn some of this particular facts important for this particular individual client or customer. Then that's what the list trade secret. Okay. Question number 3, what can we do to stop them from using the customer list? Okay. What I list here is the legal options that we have. Before we go into that route, I always recommend client to sit down with this person and see if there's a whether or not the issue can be resolved. Okay, take out the emotion, take out the ego, out of discussion, and just sit down and see if there is an opportunity to resolve the issue without court action. Many times, in a business scenario, many times we can resolve the issue. Sometimes you just can't, right? If you know the other side is not forefront with the information, then it's not open or it's not sincere to have discussion, then obviously you need to go to the first next step. Now, assuming that you have done that, and what are the legal options that you have? Well, at that time, you have no choice but file a lawsuit. Then we will seek temporary restraining order or preliminary restraining order. What I mean is that you want to get a court order or injunction from the court before the trial, or before the court has a determination or rendering a judgment on the trial day, which generally is about 1 year later. But you cannot wait that long. You need to have an injunction right now. That's the time that you file a temporary restraining order, or TRO. We generally hear that term, or preliminary injunction. Okay. 2 things that the court will look for is whether or not you need to tell court why you cannot wait for 1 year, why there's an urgency, exigent circumstances, the court call it, why there's an urgency that you need to have such court order to prevent this person from doing certain things, to use your customer list, to approach your vendors, things, or continue to use the company resources that they did not legally take from you. Okay, you need to explain to the court. The second prong is you need to explain to court, if the court doesn't issue the injunction right now, before the trial day, before the court has the opportunity to hear the case from both sides and make that determination, why the court should act. The most scenario, you need to tell court that if the court doesn't act, you're going to be harmed to the point that even you win a lawsuit 1 year later, you will not repair your company. You will not repair the damage. Okay, in legal term we call it irreparable harm. It's not something that can be repaired, even though you win the case 1 year from now. And those two, if you satisfy those 2 prongs, then the court will most likely issue an injunction. So pretty much the injunction is a mini trial in court, through paper, through declaration, through documentary evidence, or if you have a testimony, we just put it on paper as informal declaration. So it's kind of like a mini trial. Sometimes if you have a strong document, 1 hearing is sufficient. If not, if the issue is really complicated, generally the court wants to know a little bit more about the case. They will put temporary restraining order first, and then have a several hearings to make sure that court understands what's going on with your case and why the injunction needs to be issued. Then the court will issue issue or deny, I should say, the preliminary injunction until the trial is over. Okay. Now, I don't want to give you expectation that once you file this, you're going to get it. The standard is really high. Judge want to make sure you have those two prongs satisfied, the urgency and also the irreparable harm requirement, because the court doesn't like to stop certain individual from doing something. That's the general thing, unless you affect you and your person, then that's the time, if court has that certainty, then most likely the injunction will be issued. The More Life versus Perry, we use this case a lot. This case is also demonstrate the court's view about injunction and also the customer list and the public policy of right to make living. Okay, so More Life filed a lawsuit against Perry, and they sought an injunction for Perry to stop approaching the customers. Now the court only issued an injunction prohibit defendants from doing business with any of the 32 clients unlawfully solicited from plaintiff. Okay, and also prevent them from soliciting any business from or entity with that did business before with More Life before they left. Okay, however, they did not prohibit defendants continuing to engage in business activity with whom that they had no contact with plaintiff and with whom that they did not acquire the information from More Life. So even though they acquired the information from the same customer, but if it's not from More Life, then they're not prohibited from doing so. So from the court's ruling, you can see the court is balancing out between the public policy of right to make a living and also the harms that you're going to suffer in terms of issuing injunction. So that's always something the court will balance it out. Now, especially, this is an interesting point. Generally, the injunction has a time period, right? But this one does not, because the court says, it's not necessary to have such. It's not necessary for injunction to last forever. Okay, but will continue if necessary to eliminate the commercial advantage derived from the customer list taken from the former employers. In other words, the court will leave it open for future debate whether or not the injunction should end or continue. So that's also shows the caution side of the court when dealing with the injunction. They want to make sure that they did the right thing for both sides. Okay. Now, the question number 4 is that